And as we sit here today, there are over 1,000 sex trafficking victims, and you have not held a single man accountable. Shame on you. If you had any decency, you would resign right after this hearing concludes.
The gentleman has expired.
May I respond?
Yeah, I don't know how you respond. No one can.
I did not ask a question, Ms.
He doesn't
You're
want
allowed
to talk
to.
about
I did
the
not ask a
horrific
question.
crime in California. He does not want to talk about
I did not ask a
crime
question.
in his state.
She can't just
Madam
ad
Attorney
lib
General.
stuff. I did not ask a question.
Meeting will be in order. The gentleman has yielded back his time.
At approximately 11:47 a.m. Eastern on February 11, 2026, the House Judiciary Committee hearing had already stretched close to 2 hours when Representative Ted Lieu leaned forward, fixed his gaze on Attorney General Pam Bondi, and delivered a sentence that instantly transformed the atmosphere inside the chamber. He did not shout it, he did not dramatize it, and he did not hesitate before saying it. Instead, in a measured and unmistakably deliberate tone, he stated, "I believe you just lied under oath," placing a direct allegation of criminal conduct at the feet of the nation's top law enforcement officer. The words were not rhetorical, and they were not symbolic. They were precise, accusatory, and grounded in a document he was prepared to present. For a brief moment, the room held still, not because anyone was unsure what had been said, but because everyone understood exactly what it meant. A sitting member of Congress had just accused the Attorney General of the United States of committing perjury during sworn testimony, and that accusation would not disappear once spoken. To understand the force of that exchange, it is necessary to return to how the hearing had unfolded before Lieu's turn began. The subject dominating the session was the handling of the Epstein files, specifically the redactions, the investigative decisions, and the absence of additional prosecutions beyond Ghislaine Maxwell, who had been charged under a previous administration. Members pressed Bondi about withheld documents, about potential co-conspirators, and about whether the Department of Justice had pursued every viable lead. Bondi responded with a blend of procedural explanations and political counterattacks, frequently redirecting scrutiny toward prior leadership at the department and insisting that victim privacy and evidentiary standards constrained what could be disclosed or pursued. Through exchanges with multiple Democratic members, she maintained an assertive posture, often deflecting criticism by reframing it as partisan theater designed to undermine President Donald Trump. When Ted Lieu's time began, he did not immediately escalate the confrontation. He started with Prince Andrew, referencing photographs that had been publicly released in connection with the Epstein materials and that had generated international headlines because of their disturbing implications. Holding the images in a manner that ensured Bondi could see them clearly, Lieu stated that the photographs constituted evidence of a crime and were more than sufficient to predicate an investigation into the former British royal. He then asked a direct question. Why had the investigation into Prince Andrew been shut down the previous July, and why had there been no prosecution? Bondi did not address the substance of the inquiry. Instead, she pivoted toward a discussion of Merrick Garland and the prior administration's decisions, effectively shifting the frame away from her own tenure and the department's current posture. Lieu did not interrupt that pivot, nor did he engage in extended back and forth over Andrew. Instead, he moved methodically to the next component of his argument, drawing a parallel between Prince Andrew and Donald Trump in terms of their documented associations with Jeffrey Epstein. He referenced the well-known video footage showing Trump and Epstein at a party, laughing and conversing in a social setting that had been public knowledge for years, but had never been formally scrutinized in this manner during sworn testimony by an attorney general. The video was played in the hearing room, placing Bondi in the position of having to confront its imagery while under oath. Lieu then asked a question that was simple in structure but significant in implication. Were there any underage girls at that party, or at any party with Jeffrey Epstein that Donald Trump attended? Bondi did not immediately answer, and the silence that followed was noticeable because of the context in which it occurred. Congressional hearings are tightly timed and highly structured. Prolonged pauses from a witness, especially one occupying the office of Attorney General, are rare and consequential. After several seconds, Bondi responded not by addressing the factual premise of the question, but by criticizing the line of inquiry itself, characterizing it as ridiculous, and suggesting that it was an attempt to distract from what she described as the positive accomplishments of Donald Trump. She then made the statement that would anchor the confrontation. There was no evidence that Donald Trump had committed a crime. The phrasing was categorical, not conditional, and it was delivered while she remained under oath. It was at this juncture that Lieu shifted from questioning to accusation. He informed the committee that he was going to introduce another document, specifically a witness statement provided to the FBI's National Threat Operations Center. His tone sharpened slightly, but he did not raise his voice. Instead, he anchored his next words in the record, asserting that he believed Bondi had just lied under oath. The allegation was not speculative. It was tied to the document he held in his hand. Bondi's reaction was immediate and forceful as she shouted, "Don't you ever accuse me of a crime!" Her voice rising in anger as Chairman Jim Jordan attempted to restore order by repeatedly striking the gavel. While the room edged toward chaos, Lieu continued in a controlled manner, stating that Bondi had just testified there was no evidence of a crime and that he was now presenting evidence to the contrary. He described the document as an FBI witness statement from 1995, provided by a limousine driver who claimed to have overheard Donald Trump speaking on a cell phone with someone named Jeffrey about abusing some girl. The driver, according to the statement, had been sufficiently disturbed by the conversation to contact the FBI at the time, and the Bureau documented his account. Lieu emphasized that this was not a recent allegation emerging after Epstein's later prosecution, but a contemporaneous report dating back nearly 3 decades. He then added another layer to the account, explaining that the same witness had told the FBI he knew a woman who claimed she had been abused by Jeffrey Epstein, and that this woman later died under circumstances in which her head had been blown off, with investigating police determining that it could not have been suicide. The gravity of that statement settled over the hearing room, not because it resolved any factual disputes, but because it underscored the seriousness of the allegations contained in the FBI's own records. Lieu stated plainly that, according to his review, no one at the Department of Justice had interviewed this witness, and that the department under Bondi had not followed up on the claims described in the statement. The core of Lieu's argument was not that the witness statement proved a crime beyond a reasonable doubt, nor that it automatically warranted an indictment, but that it constituted evidence and that Bondi's assertion of no evidence was therefore inaccurate. In a legal context, the term evidence encompasses witness statements and documentary records, even when they have not yet been corroborated or tested in court. By testifying categorically that no evidence existed, Bondi had made a factual claim about the contents of investigative files over which she exercised supervisory authority. Lieu's presentation of the FBI document was intended to demonstrate a contradiction between her sworn statement and the documentary record. As the confrontation unfolded, the significance extended beyond the personalities involved. Perjury under federal law requires that a person, under oath, knowingly make a false statement that is material to the proceeding. Bondi had been sworn in at the start of the hearing, and the subject matter of the session centered on the Epstein investigation and potential co-conspirators, rendering her statements about evidence directly material. Whether her assertion was knowingly false would hinge on what she knew about the witness statement and how she interpreted the phrase, "no evidence." But the contradiction had now been placed squarely on the record. In less than a minute, the hearing had shifted from a debate over prosecutorial discretion to a potential question about the Attorney General's own compliance with the law. The confrontation did not end with the shouting, nor did it dissolve once Chairman Jim Jordan's gavel managed to carve out a narrow strip of procedural order inside a room that had already crossed into something more volatile than routine oversight. What had just occurred was not a stray accusation hurled in anger. It was a formal allegation tied to documentary evidence, delivered under circumstances that made retreat nearly impossible for either side. Pam Bondi had testified that there was no evidence that Donald Trump committed a crime in connection with Jeffrey Epstein, and Ted Lieu had placed an FBI witness statement into the record that described conduct which, at minimum, demanded investigation. The tension now revolved around a single question. Did the Attorney General speak inaccurately, or was she attempting to narrow the definition of evidence to something more convenient? Bondi attempted to reassert control by insisting that the witness statement Lieu referenced did not amount to proof of criminal wrongdoing and that accusations alone did not create a prosecutable case. Her argument, stripped of emotion, leaned on a familiar prosecutorial principle. Not every allegation becomes a charge, and not every statement rises to the level of actionable evidence. Yet that was not the claim she had made moments earlier. She had not testified that there was insufficient evidence to prosecute, nor had she said that the material lacked corroboration. She had declared there was no evidence, a phrase that carries a different and far more absolute meaning in a legal context. Lieu recognized the distinction and refused to allow the record to be blurred by post hoc reinterpretation. He clarified that the FBI document he held was not hearsay plucked from a political blog, but an official witness statement taken in 1995, cataloged within federal investigative files and preserved as part of the Bureau's institutional record. The limousine driver, according to the document, claimed he overheard Donald Trump on a cellular phone speaking with someone identified as Jeffrey about abusing a girl, language that, if true, would implicate potential criminal conduct. The driver's reaction at the time was not indifference. He contacted the FBI's National Threat Operations Center, prompting the creation of a formal record. The existence of that document, Lieu argued, constituted evidence in the most basic legal sense, regardless of whether prosecutors later determined it was strong enough to sustain charges. The deeper issue Lieu pressed was not whether Trump should have been indicted in 1995 or at any later date, but whether the Department of Justice under Bondi had an obligation to follow up on such a statement once it resurfaced within the broader review of the Epstein files. If the department had ignored it, that omission would raise questions about investigative diligence. If it had reviewed and dismissed it, then Bondi should have been prepared to explain that review rather than assert the total absence of evidence. Liu's point was methodical. You cannot categorically deny the existence of evidence when a documented witness account sits in your own agency's archives. To do so risks converting a policy defense into a factual misrepresentation. Bondi's response oscillated between indignation and procedural defense, suggesting that members of Congress were attempting to criminalize political association and that the mere mention of Trump's name in a decades-old statement did not equate to proof of wrongdoing. Yet Liu's framing did not require proof. It required only acknowledgement. He repeated that the document described an alleged conversation involving Trump and that the witness further connected Epstein to a woman who later died under suspicious circumstances. According to Lieu, investigating police concluded that her death could not have been suicide, a detail that intensified the gravity of the witness's account even if it did not conclusively tie Trump to any crime. As the exchange continued, the analytical focus shifted toward the legal standard for perjury. Under federal statute, a person commits perjury if they willfully state or subscribe to any material matter which they do not believe to be true while under oath. The elements are clear: a false statement, knowledge of its falsity, and materiality to the proceeding. Bondi had been sworn in, satisfying the oath requirement. Her statement about the absence of evidence directly related to the committee's inquiry into the Epstein investigation, satisfying materiality. The remaining questions, therefore, centered on falsity and knowledge, and those questions could not be dismissed by rhetorical outrage. Lieu emphasized that, as Attorney General, Bondi oversaw the review and release of the Epstein files and therefore could not plausibly claim ignorance of significant witness statements contained within them. If she was unaware of the 1995 FBI record, that suggested a failure of oversight at the highest level of the Department of Justice. If she was aware of it, then her categorical denial of evidence became harder to defend. Either scenario carried consequences, though of different kinds. Incompetence and perjury are not interchangeable accusations, but neither is acceptable for the nation's chief law enforcement officer. The hearing room's dynamic reflected that gravity. Other members attempted to interject, some supporting Bondi's characterization of the witness statement as unverified hearsay, others pressing for clarification about whether the department had interviewed the limousine driver. Chairman Jordan's repeated calls for order underscored that the exchange had crossed from policy disagreement into potential criminal implication. Yet beneath the procedural noise, the record was being built line by line, and every word spoken would remain accessible long after the gavel fell. Lieu's objective appeared less about winning the moment than about preserving a contradiction that could later be examined by investigators or legal scholars. Bondi's defenders within the committee suggested that no evidence should be interpreted as shorthand for no credible prosecutable evidence, arguing that prosecutors routinely evaluate tips and allegations that never mature into cases. That is true as a matter of practice, but it does not erase the distinction between evidence and proof. A witness statement, even if later deemed unreliable, is still evidence. Its credibility must be assessed through investigation, not assumed away. Lieu underscored that point by stating that the department had not interviewed the witness, meaning that any judgment about credibility would have been made without direct examination. The discussion also touched on institutional accountability. If a witness statement alleges criminal conduct and remains unexamined for decades, the public may reasonably question whether investigative priorities were shaped by political considerations rather than legal merit. Bondi countered that the department must allocate resources strategically and that revisiting every historical allegation is neither practical nor legally required. Yet that defense does not address the specific contradiction created by her sworn assertion. Even if resource constraints justified inaction, they do not transform existing documents into non-existence. As the second phase of the exchange unfolded, legal experts outside the chamber began commenting on the implications. Former prosecutors noted that perjury cases against high-ranking officials are rare and difficult, particularly when disputes hinge on interpretation of language rather than clear factual falsehoods. Proving that Bondi knowingly made a false statement would require evidence that she was aware of the witness statement and understood that it constituted evidence within the scope of the committee's inquiry. Such proof might involve internal communications, briefing materials, or testimony from department staff regarding what she had been told before the hearing. The burden of proof in a perjury case is high, and prosecutors must demonstrate intent beyond a reasonable doubt. Nonetheless, the presence of an FBI document in the record complicated any effort to dismiss Lieu's accusation as purely political theater. The statement existed. It described alleged criminal behavior, and it had not been investigated according to Lieu's account. The gap between Bondi's categorical denial and the document's existence created a legal tension that could not be resolved through volume or indignation. As the hearing moved toward the close of Lieu's allotted time, the central contradiction remained intact, embedded in the transcript and captured on video for public scrutiny. What had begun as a question about investigative decisions had now evolved into a dispute about the Attorney General's own truthfulness. Whether that dispute would mature into formal proceedings depended on actions beyond the hearing room, potential referrals, internal reviews, or independent investigations. But in that moment, the essential shift was complete. The focus was no longer solely on Epstein, nor even on Trump's historical associations, but on whether the nation's top law enforcement official had misstated a material fact under oath and whether that misstatement would carry consequences. As the hearing advanced beyond the immediate clash, the conversation hardened into a legal examination of what had just transpired rather than a continuation of partisan argument. The core issue was no longer whether the limousine driver's statement was credible, sensational, or politically inconvenient. It was whether Attorney General Pam Bondi's sworn declaration that there was no evidence of criminal conduct by Donald Trump could withstand scrutiny in light of a documented FBI record describing alleged abuse. Members of the committee understood that rhetoric would fade, but transcripts endure, and perjury is evaluated not by emotional tone, but by statutory elements. That shift from spectacle to structure marked the beginning of a more consequential phase. The analysis became technical, and in a matter involving the Attorney General, technical details are where careers are either salvaged or dismantled. Under federal law, perjury requires proof that a witness knowingly made a false statement about a material matter while under oath. Bondi was indisputably under oath, and no serious observer disputed that her assertion regarding the absence of evidence went to the heart of the hearing's subject matter, which centered on the scope and integrity of the Epstein investigation. The debate therefore narrowed to two interlocking questions. Was the statement false? And if so, did Bondi know it was false when she made it? Lieu's presentation of the FBI witness statement addressed the first question by challenging the literal accuracy of her claim. If a witness statement describing potential criminal conduct existed in department files, then evidence existed in the plain meaning of the term. Bondi's defenders attempted to introduce nuance, arguing that in prosecutorial practice, evidence often functions as shorthand for evidence sufficient to sustain charges, not merely any allegation reduced to writing. That interpretation might be plausible in casual conversation, but sworn testimony before Congress is not casual conversation. When the Attorney General states that there is no evidence of a crime, the presumption is that she is speaking in factual terms about the existence of materials in the investigative record, not about her subjective assessment of their prosecutorial strength. Lieu pressed that distinction carefully, reiterating that he was not claiming the limousine driver's account had been validated in court, but that it had been recorded by the FBI and left unexamined by the department under Bondi's leadership. The second question, knowledge, posed a more complicated challenge. To establish perjury, prosecutors would need to show that Bondi was aware of the witness statement and understood that it fell within the category of evidence relevant to the committee's inquiry. As Attorney General, she supervised the review and release of the Epstein files, a process that would have involved briefings from senior officials regarding sensitive materials. If internal memoranda or preparatory notes indicated that she had been informed about the 1995 FBI statement before the hearing, that documentation could weigh heavily in assessing intent. Conversely, if there were credible indications that she had not been briefed on that specific record, the issue might shift from willful falsehood to institutional oversight failure. Lieu's strategic restraint became increasingly apparent during this phase. Rather than inflaming the exchange further, he laid out the elements methodically, creating a roadmap for potential future proceedings. He emphasized that the witness statement did not prove Trump's guilt, but that its existence contradicted the Attorney General's blanket denial of evidence. He underscored that the department had not interviewed the witness, meaning that the credibility of the allegation had never been tested through standard investigative procedures. That omission, he argued, compounded the seriousness of the contradiction because it removed the possibility that the department had evaluated and rejected the claim on evidentiary grounds. Beyond the perjury question, Lieu broadened the focus to institutional accountability. He noted that more than 1,000 sex trafficking victims had been identified in connection with Epstein's network, and that, to date, no additional individuals beyond Ghislaine Maxwell had been prosecuted under the current department's tenure. The implication was not merely that Bondi had misstated facts, but that the department had failed to pursue leads with the urgency warranted by the scale of victimization. The absence of indictments, when paired with unexamined witness statements, created a narrative that suggested either investigative paralysis or selective enforcement. Lieu's closing remarks in this segment were measured but pointed, asserting that if Bondi possessed any sense of institutional responsibility, she should consider resigning. The call for resignation was not theatrical. It was framed as a logical consequence of the alternatives Lieu had outlined. If Bondi did not know about the witness statement, she presided over a department insufficiently briefed on critical evidence. If she did know and still testified that no evidence existed, she risked having made a materially false statement under oath. Neither scenario reflected well on the integrity of the office she occupied. Lieu's argument thus placed Bondi at a crossroads where each path carried reputational cost, even if only one could lead to criminal liability. Outside the hearing room, legal analysts began dissecting the exchange with caution. Perjury prosecutions against senior officials are rare, not because the law is ambiguous, but because proving intent beyond a reasonable doubt is difficult, particularly when disputes hinge on definitional nuance. Courts examine whether a statement was literally false or merely misleading, and they consider whether the witness may have interpreted a question in a narrower sense than the questioner intended. Bondi could argue that by no evidence, she meant no substantiated, corroborated evidence sufficient for prosecution, and that the limousine driver's statement did not meet that threshold. The viability of that defense would depend on how clearly she articulated her position during the hearing and whether she attempted to clarify her earlier words. At the same time, critics pointed out that the Attorney General is expected to exercise precision in language, especially when addressing Congress under oath. A categorical denial carries weight precisely because it leaves no room for ambiguity. If Bondi wished to distinguish between types of evidence, she could have done so explicitly rather than making an absolute claim. That rhetorical choice now stood as a focal point for potential investigation, and it underscored the broader principle that officials who oversee the enforcement of perjury statutes are themselves subject to them. As the third segment of the confrontation drew toward its close, the hearing's atmosphere remained tense but more disciplined. The initial shouting had subsided, replaced by a more sober recognition that the record had been irrevocably altered. The FBI witness statement was part of the transcript, Lieu's accusation was part of the transcript, and Bondi's denial was part of the transcript. Whatever political interpretations followed, those facts would not change. The issue would now move beyond the immediacy of the hearing into quieter spaces where referrals, reviews, and legal memoranda shape outcomes. The significance of that shift cannot be overstated. Congressional hearings often produce dramatic exchanges that dissipate once media attention shifts, but allegations of perjury against a sitting attorney general do not evaporate easily. They invite scrutiny from inspectors general, from career prosecutors, and potentially from special counsel if conflicts of interest are alleged. Whether such mechanisms would be activated remained uncertain, but the possibility itself altered the political landscape. Bondi's tenure, once defined primarily by her alignment with the administration's policy agenda, now faced a question about personal legal exposure. In that sense, the hearing had crossed from oversight into self-referential accountability. The Department of Justice, tasked with enforcing federal criminal law, found itself under scrutiny for the conduct of its leader. The contradiction between sworn testimony and documentary evidence created a tension that demanded resolution, either through clarification, investigation, or formal proceedings. Lieu's measured approach ensured that the matter could not be dismissed as mere partisan provocation. He had anchored his accusation in a document and in the statutory language governing perjury, thereby transforming a political clash into a legal inquiry. By the end of this phase, one conclusion was unavoidable. The narrative had expanded beyond the Epstein files and beyond Trump's historical associations. It now encompassed the credibility of the Attorney General herself. The remaining question was not whether the exchange had been dramatic, but whether the institutions responsible for upholding the rule of law would examine it with the same rigor applied to any other witness accused of making a false statement under oath. By the time the hearing adjourned, the immediate shouting had faded, but the implications of what had occurred continued to expand outward, moving from the committee room into the broader architecture of institutional accountability. The question was no longer confined to whether Ted Lieu had overreached in accusing Attorney General Pam Bondi of lying under oath, nor whether Bondi had simply spoken imprecisely in the heat of confrontation. The deeper issue had become structural. How does a legal system premised on equal application of the law respond when the individual charged with enforcing that law is accused of violating it herself? The gravity of that question extends beyond party affiliation and beyond the personalities involved, because it touches the foundational principle that sworn testimony must carry consequences when false. In the days following the hearing, legal analysts dissected the transcript line by line, paying particular attention to the exact phrasing Bondi used and the context in which it was delivered. Her statement that there was no evidence that Donald Trump committed a crime was examined alongside the FBI witness statement from 1995 describing the limousine driver's account of a phone conversation about abusing a girl. Scholars debated whether the existence of a documented allegation necessarily qualifies as evidence in the strictest prosecutorial sense, or whether the Attorney General could plausibly claim she was referring to evidence sufficient to sustain a criminal charge. This distinction, while subtle, became central because perjury cases often hinge on whether a statement is demonstrably false rather than merely misleading or incomplete. At the same time, attention turned to the Department of Justice's internal processes, particularly how briefing materials are prepared for high-profile hearings and what information is conveyed to the Attorney General before she testifies. If documents surfaced showing that Bondi had been briefed specifically on the 1995 witness statement, the argument that she spoke unknowingly would weaken considerably. Conversely, if the department's internal review of the Epstein files failed to highlight that document, the problem would shift toward systemic oversight failures rather than intentional deception. Either scenario carried reputational consequences, but only the former would satisfy the willfulness requirement necessary for perjury prosecution. Members of Congress sympathetic to Lieu's position suggested that a referral to the department's office of the Inspector General might be appropriate to determine whether Bondi's testimony was accurate and whether the limousine driver's statement had been adequately investigated. Critics of that proposal countered that referring the matter internally could create conflicts of interest, given that the Inspector General operates within the same department led by Bondi. Some floated the possibility of appointing an independent counsel if sufficient evidence of wrongdoing emerged, though such appointments are rare and politically charged. The mere discussion of these mechanisms underscored that the controversy had escalated beyond routine oversight disagreement. Public reaction intensified the pressure. Advocacy groups representing victims of trafficking argued that the department's handling of the Epstein files required renewed scrutiny, not only because of the perjury allegation, but because of the broader concern that numerous potential co-conspirators had not faced prosecution. The fact that more than 1,000 victims had been identified in connection with Epstein's network amplified the perception that investigative inertia could not be justified by resource constraints alone. Bondi's categorical denial of evidence now appeared in tension not only with the FBI document, but with the broader expectation that every credible lead should be examined thoroughly. Even if the limousine driver's statement ultimately proved unreliable, the absence of documented follow-up fueled suspicion. Bondi and her allies sought to reframe the narrative by emphasizing prosecutorial discretion and the principle that allegations must be substantiated before charges are brought. They argued that reviving decades-old claims without corroboration risks politicizing criminal law and undermining due process. That argument carries weight in any legal system committed to fairness, yet it does not resolve the narrower issue of sworn testimony. The question was not whether Trump should have been charged in 1995 or 2026. It was whether the Attorney General accurately described the contents of her department's files when she denied the existence of evidence. Precision in language is not optional when speaking under oath before Congress. As the controversy unfolded, the political stakes grew clearer. Bondi's tenure as Attorney General had been closely tied to her alignment with the administration's priorities, and critics contended that her categorical defense of Trump during the hearing suggested political loyalty overshadowing prosecutorial independence. Supporters rejected that framing, insisting that she was protecting the integrity of an investigation from partisan attacks. Yet the appearance of partiality can be as damaging as proof, particularly for an office that depends on public trust. If the department is perceived as shielding allies or dismissing allegations without scrutiny, confidence in its impartiality erodes. Ted Lieu's role in this dynamic remained consistent with his conduct during the hearing. He did not claim that the witness statement proved Trump's guilt. Rather, he maintained that the existence of the document contradicted Bondi's sworn assertion. By anchoring his accusation in statutory language and documentary evidence, he positioned himself less as a political adversary and more as an advocate for procedural accountability. Whether his accusation ultimately results in formal proceedings depends on factors beyond his control, including the willingness of institutional actors to pursue the matter further. Nonetheless, the record he created cannot be erased. The broader constitutional context also loomed large. Congress's oversight authority exists precisely to ensure that executive branch officials remain accountable, and sworn testimony is one of the mechanisms through which that accountability is enforced. If an attorney general can make categorical statements under oath that are contradicted by internal documents without consequence, the deterrent effect of perjury statutes diminishes. Conversely, pursuing perjury charges against an attorney general without clear evidence of willful falsehood risks weaponizing criminal law for political ends. The balance is delicate, and the decision about how to proceed carries implications for future oversight battles. In practical terms, the path forward would likely involve document review, internal memoranda analysis, and potentially closed-door interviews with department staff involved in preparing Bondi for the hearing. Investigators would examine whether she was briefed on the 1995 FBI statement, how that statement was characterized in internal discussions, and whether any decisions were made regarding follow-up investigation. They would also assess whether her phrasing during the hearing left room for interpretive defense, or whether it constituted a literal denial inconsistent with known facts. Such inquiries are slow and methodical, often unfolding far from the public eye. Meanwhile, the political narrative continued to evolve. Opponents framed the episode as emblematic of a department unwilling to pursue evidence implicating powerful figures, while supporters depicted it as an example of partisan overreach seeking to criminalize ambiguous language. Media coverage amplified both interpretations, ensuring that the issue would not dissipate quickly. The viral clip of Bondi shouting in response to Lieu's accusation became a symbol, but the enduring significance lies not in the emotional intensity of that moment, but in the legal question it raised. Emotional reactions fade. Transcripts endure. Ultimately, the final outcome will depend on whether institutional actors treat the contradiction as a serious matter warranting formal examination or as a political skirmish best left to public debate. If a thorough review concludes that Bondi knowingly misstated the facts, the consequences could include resignation, referral for prosecution, or congressional censure. If the review determines that her statement reflected a defensible interpretation of evidence, the episode may be remembered as a heated but legally inconclusive exchange. In either case, the hearing altered the trajectory of her tenure by placing her credibility under scrutiny. What remains indisputable is that the events of February 11th reshaped the conversation around the Epstein investigation and around the role of the Attorney General in safeguarding the integrity of that inquiry. A single categorical assertion, challenged by a documented witness statement, triggered a chain of legal and political consequences that continue to unfold. The rule of law is tested not only by how it treats ordinary defendants, but by how it responds when allegations reach the highest levels of government. Whether the system will apply its standards consistently in this instance is a question that extends beyond Pam Bondi and beyond Ted Lieu, reaching into the core of constitutional governance itself.